And our presenter today is Michael Rosinski. Michael is an RIT alumnus and a certified financial planner who specializes in goals-based investment planning, retirement planning, planning for corporate executives, including employee stock options and equity compensation planning, as well as estate planning, including family legacy and governance. After many years of working for large organizations, Michael recently formed his own fee-only financial planning firm, Iron Dome Financial Group. Michael has a master's degree in taxation and a bachelor's degree in finance. Michael is also currently working toward his JD. Welcome, Michael, and let's get started.
Well, thank you, and thanks for having me. It's my pleasure to be here. I just want to make sure everyone can hear me, so if you can't, let me know. Otherwise, I'm assuming you can. Let me say this. I often say this to clients, that I'm the life of the party, because when I show up, we talk about death and taxes. And so it's lunchtime, so I'm going to try to make this as painless and as entertaining as possible to the extent it is possible, given the morbid subject matter. So it would be easy for me to sit here and talk for an hour, but what I would also say is, please, the subject matter is a little bit technical. Some things, unless you talk about them every single day, may or may not be familiar to you. Feel free. I encourage you to type in the questions. I will see them come in, and I will try and answer. I will make frequent stops along the way, and I'll try to answer them as soon as I can. Now, having said that, before I get into it, I have a question for you. Without thinking, just when you think about estate planning, don't give it any thought. Just type in one word that you think of when you think estate planning, and you just fire away. And in the meantime, we're going to take a look at estate planning in numbers so we can get the tax piece out of the way. Okay, so while you're typing, I am going to cover estate planning in numbers. So the federal government allows you to transfer, either while you're alive or at death, about $5.45 million to anyone you wish. So assuming you have $5 million, you can transfer it to anyone you want, either while you're alive or when you die, and there is no tax. For a married couple, it's a little over $10 million. So assuming your estate is under $10 million, you theoretically have no tax liability. The state of New York has a different exemption. It's a little bit less, but it is scheduled and slowly, gradually getting up to the federal exemption of $5 million. I think it's going to be you can see it's 5.25 beginning of April 2017. It is scheduled to catch up with the federal exemption. So the common sort of misconception oftentimes is, well, you know, I don't have a taxable estate. Why should I bother with estate planning? Estate planning is only for rich and famous. Well, be that as it may, as you'll see, many of the mistakes that are made by rich and famous are the same mistakes that keep from clients every single day. They're no different, and they're all human mistakes. They're not the tax piece. The tax piece is actually easy. And I tell the clients all the time, if this meeting was about taxes, we can be done in 5 minutes, right? So we're just talking about tax piece, straight mathematical calculation, we get rid of the tax, done. But we're not. You'll see how difficult it gets when we start talking about human issues and family dynamics and family governance and values and so on and so forth. And so I see some answers coming back to me. Okay, so there's a word, trust, wills, expenses. And this was kind of what I expected to see, right? And I'll get to you what my answer is, but I'll just emphasize once again what I said a few minutes ago. The estate planning of folks who are celebrities, rich, famous athletes, lots of money, are the same mistakes we all make, except they have just a few more zeros at the end of their estate balance sheet. Now, in my years of practice, about 15 plus years of practice, I came up with these following 4 reasons why I think these mistakes are made. Right now, I don't claim to say this is all it is. There may be some other reasons, but this is what kind of stood out for me. Number one, obviously, is magnified by fame and fortune. You have a lot of money, so you have a lot of people talking to your ear, trying to be your friend, just saying entourage, and so on and so forth. So there are influences. So there are influences by advisors, people in your circle, friends, people pretending to be friends. There's also a lack of cohesive strategy among multiple advisors. I mean, I see this all the time with my clients. So when attorneys don't speak to accountants, accountants who don't speak to financial advisors, and a circle goes on and on and on, everyone's being sort of very protective of the turf. In the end, and you'll see this in a few minutes, the person who suffers is the client, whether it's you or it's a rich and famous person. It doesn't really make a difference. And the last piece as well, it is oftentimes is sold. I mean, I put it in quotes because there's a lot of good intentions, a lot of good planning, but if you don't explain the underlying reason for it, it is so technical and it's so sometimes complex. The clients kind of freeze, and instead of making a rational decision, they essentially just say, okay, so that sounds good to me, let's do it. And you'll see how it all plays out. Oh, I apologize for not advancing the slide. That's right, I kind of got carried away. Oh, sorry, this is, gotta keep my pace here. So yes, this was the slide I was talking about. Magnified by fame and fortune, influenced by outside interests, like his strategy and sold to the principal. Okay, now, once again, so the answers were trust, wealth, and expenses as far as what you think of when you think about estate planning. Well, my answer is different. My answer is love. This is an article I actually read in the Financial Planning magazine not too long ago, but I wholeheartedly agree with it. Because estate planning is not about tax work. I mean, yes, it is about taxes and minimizing expenses and so forth and so on, but more importantly, it is about love. It is about love for your family members, for your loved ones, for those you leave behind. Because remember, you're dead. It doesn't matter to you. It doesn't matter to anyone who's passed away. You're deceased. You've moved on to the undiscovered country. You don't care. People who you leave behind will have to clean up the mess. So the question becomes then, okay, well, just how much of a mess do you want to leave? Do you want your loved ones to have to go to court and fight over unclear, intentions, or fight over some of the things that you weren't clear about, or fight over personal items, or so on and so forth? There's a lot of things that come out of the woodwork and not given enough money. So it's not so much about control, it's all about love. And I always try to explain this to clients. It's about love. Let's start with that. We'll get to the tax piece in sort of a roundabout way, but think about what you want to happen. Who do you want to have what and when? And a good example of that is, I live in New Jersey. I went to school in Rochester. I have family in Rochester. I come up all the time. I live in New Jersey, so I couldn't resist putting Tony Soprano, also known as James Gandolfini, as a perfect example of this. Sort of planning. He died unexpectedly, although maybe he knew he was sick or had a heart disease, who knows, right? But he died fairly at a young age. And his will, by the way, there's a link to his will if you have trouble going to sleep. Feel free to click on the link and take a look at it. But essentially what it says, 30% of his estate went to his two sisters, 20% to his wife, and 20% of his daughter. So all are good intentioned, probably driven by love decisions, except, but not tax efficient. So going back to my previous slide, and I'll just go back to this slide, right? So was there lack of strategy? Was it a lack of communication? Was it just sold to him? I don't know what the answer is, but I know what the end result was. I'm sure he had good intentions, and I'm sure whoever put this in place had good intentions, but because of lack of coordination, his estate paid additional taxes that didn't have to be paid, accomplishing the same thing. Now, take a close look at the last bullet point that says, life insurance policy that isn't subject to estate tax. And then my little addition that says, is it? That's my question for you. I'll answer it at the end, but I want you to think about this, because oftentimes we hear this from the television programs, from popular entertainers in terms of the financial so-called news, call them entertainment channels, that, hey, life insurance is not taxable, and certainly folks who sell life insurance will tell you the same thing. Well, it is and it isn't, so we'll get to that. Let me stop here for a second. I know it's kind of going at a rapid clip, so let me know if anything here needs any additional explanation. If not, absent any comments, I'll move on. Okay, I don't see any, so I'll be moving on. You know, of course, I couldn't resist. Obviously, it's in the news. So Prince died, and he apparently died without having a will in place. So that's a mistake, number one. It's sort of so obvious and so common that it just almost doesn't make sense to even mention it, but it does. And I'm going to ask the rhetorical question. You don't have to share it with me. Just ask yourself, how many in the audience have a valid will, been executed, signed, and witnessed? I'm willing to bet, and that's my bet, probably at least 50% of you don't have a will. Or have a will you haven't looked at in a long time. Happens all the time. So Prince, obviously, his estate is going to have a lot of money. It looks like $300 million plus all the royalties his estate is entitled to. There's going to be a lot of money at stake. Having no will, you're essentially allowing the government to be a partner in your estate. So now the judge, looks like in the state of Minnesota, is going to have to decide who gets what, when, what percentages. And I guarantee you, given that much money at stake, there's going to be all kinds of people coming out and claiming that they are entitled to some piece of his fortune. All of this could have been easily avoided if the will was put in place. So my practical solution to this, you're going to laugh at this, but I want you to, is simple. Don't die without a will. Please don't. I often say this to clients. Would you like federal and state governments to be, in certain cases, 50% partners in your estate? If the answer is no, if you don't want the government to be making decisions who is going to take care of your minor kids, then please have a will in place. Name some agents, okay? And we'll get to the agents later, but that is mistake number one, having no will in place. Okay, looks like we have a question. Let me stop here for 1 second. Okay, good question. So the question is on, actually it's a response to my question on life insurance. Okay, so I'll keep that in mind, Robert. I will get back to this, but your answer is technically correct. There are some cases when insurance may be income taxable, but by and large it's not. So, but we'll get to that. The answer is what you typed in is correct. Now, let's go back to mistake number two. Okay, so individuals who you name in your will as the guardians of your minor kids, or the agents such as executors, or potentially executors, trustees of your trust, essentially trustees of any trust you may be creating under the will, or may have created when you were alive. These are the individuals who you are in trust, because the trust is nothing more than an agreement between you, the trustor, and a trustee who will take care of your property. Either it could be a trust set up while you're alive or when you die, so it's nothing more than just an agreement. So the individuals who you name in your documents will be responsible for taking care of your property, will be responsible for administering your estate, probating your will, making a lot of important decisions. So you have to be able to trust them, right? Now, some individuals who we think we can trust, we can't, and these are good examples of this. Jackie Kennedy is one of them. And this is, I don't even think it's an issue of trust. I don't really know what exactly happened, but here's my guess. She left her assets, and so essentially what she did, if you take the fancy term disclaimed, what she basically said is this. Look, John and Caroline, here's my estate. You have the right to say, to the extent you don't want any of this money or some of this money, put that money to charitable use. Fund the charitable trust to the extent you don't want the money. So either they never got around to it, John and Caroline. Of course, John fortunately passed away. died in the airplane crash, or they just consciously decided not to disclaim anything and just use the money themselves. I don't know. But the issue is, if she were a little bit more specific, or if she communicated that with them, perhaps the result would have been different. The example number one, just a pure embezzlement. Someone just decided to use the money for themselves, right? So, again, my practical solutions to that are kind of simple as well. Look, communication. How many times I see this with clients? All the time. They would name someone, a brother or cousin, in-law, you name it, as their agents in their wills, and they've never spoken to that individual. They just think, they assumed that they will take care of what needs to be taken care of. Do you know if they're financially savvy? Do you know if they want to actually serve? When you say they will take care of your children, do you really think they can? Do they want to? Do they have the financial wherewithal to do so? These are all the questions. And by the way, I will say this about myself. One of the most difficult decisions and one of the most difficult impediments to actually having a will in place for an average married couple with kids is the fact that they can't agree on who's going to take care of the kids. Now, when I said we, that's a Freudian slip, because myself and my wife, for the longest time, just couldn't agree on that. There was a big disagreement. We just couldn't find anyone who would actually be able to take care of our children. So it's a difficult thing to talk about. So communication is key. Now, there's some other options, right? You can consider a corporate trustee or a corporate co-trustee. You can hire an investment professional, or you can give the trustees the power to hire an investment professional to manage the trust. You can also name a trust protector, someone who has the right to oversee the trust in the operation of the trust to make sure nothing funny happens. So just don't be intimidated. A lot of times when you think corporate trustee, well, I don't have I don't have a lot of assets, I don't have the big estate, I don't need a corporate trustee. Well, remember, this is not for when you're alive. This is when you're dead. So if your will creates a trust, perhaps if you think about everything that's going to be sold and put in the trust, perhaps you want to have a corporate co-trustee so that a loved one who you named in the will actually have someone who can sort of keep an eye on them and make decisions with them. And now my screen went blank, and I think my laptop went to sleep, so give me 1 second to wake it up. Apologies for that. Come on. Okay. My laptop is not cooperating. Oh, I'm back in line. Sorry about that. I am in business. Okay. Mistake number 3. This is an interesting case, leaving your intent unclear. This is a very interesting case, in my opinion. So we all know the tragic death of Whitney Houston, and she passed away, and she had a drug problem and all that. Now, apparently her father died in 2002. Well, not apparently, he did die. And so he sued her for $1 million because apparently for his estate, his contention was that she owed him $1 million for something. Now, years later, that came up, and I don't think the battle is settled. So essentially what happened was he took out a policy for $1 million. He named Whitney as the beneficiary of the policy, but apparently his intent was for her to take the money and pay off the mortgage that his spouse at the time essentially took out, and Whitney held the mortgage on the house that the ex-spouse or the surviving spouse occupied. So to make a long story short, the father thought that Whitney should pay the money back to the estate, and Whitney said, heck no, I'm not paying it back. It's my money. I'm the beneficiary of the estate. And sort of it created a lot of animosity because a lot of dirty laundry came out. Wills are public, by the way. Remember, as soon as you file a will in the probate court, it becomes a matter of public record. So everyone can see that. And so Whitney made a public spectacle out of it, going in and basically talking about how this surviving spouse was 40 years younger than her father, and they started dating while he still was married to her mother, and yada, yada, yada. It became a very sort of ugly fight. And in the large scheme of things, with her estate, $1 million, probably not that much money, but because of his intent wasn't clearly specified, and although the beneficiary designation trumps your will, apparently there were some letters written saying, well, I really meant X instead of saying Y. So this could happen. Practical solution is, again, not that difficult, but I see this all the time. Be specific. In your wills, make your wishes specific. The more specific you can be, better off you are. Okay, now, this is with respect to individual personal property here, okay? If and when you die, you take a will and you take it to court, it has to be probate. In other words, it has to be proof, right? Comes from Latin word, it has to be proof. So the court essentially has to look at it and say, yeah, it's a valid will, it's been witnessed, yeah, so okay, go ahead, collect the property, distribute the property. The problem is, oftentimes, there are some decisions and some things that need to be made right away. Also, you may have some items of personal property who you want to be inherited by certain individuals. Some family sentimental values, you know, your favorite car, your favorite jewelry, piece of jewelry, or something else that's been in the family for a long time. So for that, I would recommend writing a memorandum of personal property. It's not as binding, but it's a letter that can be sort of filed or left behind with someone who knows where that letter is. It's not as official as a will, but it's essentially a letter of wishes and it's a memorandum that tells which property should be transferred upon and passed on to certain individuals, okay? Again, it's not binding. It can still be challenged through the will, but chances are it won't be, because usually the wills will just say distribute the property accordingly or distribute the property sort of equally among the siblings, let's say, or the children. So, but if you want someone specifically have something, leave a letter of intent or memorandum of personal property. I am stopping here. If you have anything else you want to ask, you can do so, but I'm going to go on and talk about Sonny Bono. Okay, so I see this all the time. I meet with a client, and we talk about estate planning, and we talk about having a will in place, and we talk about having a power of attorney in place, or having a healthcare proxy in place, or a living will in place. And we meet a year later, and the client hasn't moved. Why? Well, I think there's a natural tendency not to want to talk about taxes, and more importantly, about death, right? So you really don't want to think about yourself and your own mortality and, well, what happens if I die? And, you know, I don't have a taxable estate. I don't want to think about it. I don't want to get in with an attorney. I don't want to pay attorney's bills, and so on and so forth. So there's a natural tendency to kind of procrastinate and wait and wait and wait and wait. But you never know when you're going to get hit by that proverbial bus. So certainly that is something that I encourage clients to do. Just bite the bullet and do it. But even with a lot of encouragement, there's still a lot of procrastination in place. Like I said, a lot of these decisions are soft decisions, not so much about the taxes. It's a lot more about who's going to do, who's going to take care of this, who's going to take care of that. And in the end, clients just freeze and do nothing. So my solution to that is there's like 4 prongs to that, okay? So have a financial professional who can help you get things done, be that a certified financial planner, a CPA, or a trust and estates attorney, someone who can actually tell you what to do, when to do it, and more importantly, push you to do it. I tell this clients again all the time is that you're paying me not so much for the knowledge. Yeah, you're paying me for the knowledge, but you're also paying me for getting things done for you. And I call it hand-holding. Again, we have a conversation, and I say, hey, you need a will in place. And you say, yeah, I do. But then a year goes by and nothing's done. That's not good. So have someone, I encourage you to have someone, hire someone who's going to help you do that. And if you don't have it done yet, if you haven't revisited, do it. There's also a checklist. I'm a big fan of checklists, so have a checklist in place. Just important documents. There's a will, there's a trust, there's a power of attorney, there is a healthcare proxy and a living will. The most important documents, the basic documents, they need to be in place, okay? Make sure you have them and sort of look at them, and we'll get back to that. Now, estate planning documents are not meant to be kept forever in the sense that things change. As you go through your stages of life, as we all go through our stages of life, things change. Kids are born, parents die, there may be future ex-spouses, there may be future ex-in-laws, who knows, right? Things change. Make sure you're flexible enough. Wills and trusts are meant to be revisited. Now, of course, with the government, there could be tax law changes. So right now, we have a regime that says, yeah, $5 million, $10 million for married couples, transfer it tax-free, no problem, right? Well, who knows? We have a next administration come in, they may have a completely different agenda, and they could change the law. The language of the current law says it's a permanent fix, but nothing is permanent with Congress, and you never know what they're going to do. So, yes, right now there is no tax if you're not above $10 million, but you never know. And by the way, just as an example, in the state of New Jersey, the exemption is only $675,000 per person. So, for instance, anyone who owns real estate in New Jersey or has a life insurance policy may have a taxable estate. So, not every state is created equal in that respect. So, tax law changes require updates as well. Just getting a little ahead of myself. Okay. Let's see. I don't know why this slide is jumping. Cindy, do you know why this is jumping forward?
No, do not.
Yeah. Okay, that's fine. I'll just talk to it. That's okay. I'll just speak to it. So there were two examples. Essentially, when someone doesn't have a will in writing, and sometimes just makes verbal promises. And I have this slide. Unfortunately, I don't know why you can't see it. It's just jumping forward in the presentation here. But when someone makes a verbal promise to someone, I'll take care of you in my will, and or doesn't write that in the will, does that give someone the right to claim sort of share of the estate? You know something? Yes and no. You can certainly make the claim, as any attorney would say. You can always make the argument. You can go to the court and say, hey, judge, you know what? So-and-so made a promise to me that they will take care of me. They forgot to write this in the will, but they did. And I'm just trying to fix this here for 1 second. Okay. Oh, there you go. So, perfect. So now we have the slide back up. So the housekeeper in this particular case alleged that there was an oral promise made. Who knows if it was made? Maybe it was, maybe it wasn't. Well, you never know unless it's actually in writing. So you can make, like I was saying, you can make the claim. You can certainly go to the court. You can tell the judge that you think the promise was made, but you actually never know if it was actually made. So have everything in writing. Now, I put Arnold in there, right? He's obviously not dead yet, and, although he's a Terminator, two-term governor, whatever, we never know. We know there's been some dark chapters in his life. There's some things that have come up in the last 10 years, and I think it's only a tip of the iceberg. There may be more, but I almost guarantee you, I don't have a crystal ball. If I did, I probably would be in a different line of business, but I almost guarantee you that there will be things coming out when Arnold passes, individuals claiming some sort of a share of his fortune. So hopefully he has good advisors, and hopefully he has everything in writing, and there'll be no issue with Arnold. But I just kind of it just kind of came to mind with his housekeeper essentially saying this is his lost child, and I'm sure that's going to come up again. And we talked about the practical solutions. Obviously, one point I wanted to make, and I think I didn't get to it just yet, is holographic wills, which is essentially a will that's written by hand, are only acceptable in certain states. New Jersey is, by the way, one of them. New York has very limited circumstances under which a holographic will be accepted. So in very limited circumstances, it may be entertained by the court. So I wouldn't rely on it. Don't write your will on a napkin. I mean, I've seen it done, but don't do it. Make sure it's properly signed and witnessed. And by the way, tell your loved ones when it's actually saved, because I've seen this again, time and again. There's a will and no one knows where it is. Time is spent trying to find it and time goes on. Okay, another one of those procrastination mistakes. Michael Jackson, he created a will and a trust, but the trust was never funded. And if you don't fund the trust, it defeats the purpose of the trust, right? Now, there's all kinds of trust, but essentially, like I've been saying before, the trust essentially is an agreement between the trustor and a trustee. The trustee will take the management of property from the trustor. So you're giving me the right to manage your property. I'll be the trustee of your trust. But if you haven't transferred anything into a trust, then you haven't accomplished anything. It's just an agreement that really has no teeth in it. There's nothing in the trust. And so if that's the case, then you're giving the family a whole lot of reasons to go back and fight over it because there's nothing that's been transferred in the trust. And there's a point in here that the wills, again, are a matter of public record. So if you have a will and it's entered into probate, that will is available to anyone. You can go in, you can actually pull it online, you can read the will, anyone's will. It's all public record. There's a way around it by having a trust set up and have a will set up where the will essentially takes everything you own, throws it into a trust, and then the trust takes place of a will. You can do it while you're alive. You can do it at death. It's not complicated. May sound more complicated than it actually is, and I venture a guess that was the intent here with Michael Jackson, create a trust, put everything in a trust so it's out of the public eye. It wasn't done. And so as the will goes into probate, everyone has a way to look at it, and essentially anyone who wants to claim something has an opportunity to do so. Whereas if you had a trust, and the will simply said, everything I own, put it in the trust, and the trust takes place of a will, then it would have been a whole different story with Michael Jackson. So with families who are concerned with privacy, and I've had clients like that, be sure that you discuss this with your advisors. This is important. Now, this is a big one as well. Forgetting to tell your loved ones where your estate planning documents are, okay? I had an elderly client who passed away 2 years ago, and she was suffering from old age dementia, and she was in a nursing home for a long time. And her husband was equally as old, although he was in the mid-90s, still pretty sharp, playing chess every week, and probably sharper than most of us at that age. But anyway, so he was also old, and she passed away, and we couldn't find her will. Her advisors had no idea where her will was, and we knew the will was in existence. We had a copy of the will. The attorney had a copy of the will. We couldn't find the actual will. So the gentleman, the survivor, the husband, took us to the condo, and you can imagine it was sort of in disarray, and we literally had to go through boxes upon boxes of things that were just thrown around and trying to find that will. It took a long time, and finally it surfaced up. It's almost like a cliche story about an old will, crusty will sitting around, but the point is it happens all the time. If you have a will, make sure Everyone knows where it is. Or, look, if you have a safety deposit box, you have an attorney, you have an advisor who you trust, or a family member, make a bunch of copies, tell them where the original is. That'll save your loved ones, not you. Again, remember, you're dead, you don't care. It'll save your loved ones a whole lot of grief down the road. You know, and I say here, don't get too creative. And you know, the hard cold cash being stored in freezers. Believe it or not, it's almost a joke, but I've seen this happen. I've actually seen people keeping cash in the freezer, certainly in the mattress. So don't get that creative. I don't advise that. Pretty difficult to find, and you know, it can burn down as well. But like I said, make plenty of copies. Certainly feel free to designate someone who will take care of this for you. And oh, by the way, now there's a lot of technology solutions. Certainly advisors offer that. I do as well. Have a virtual vault. You could scan and save your documents in one place. Have one password and all copies of very important documents if you trust that is, if you trust sort of the cloud technology and if you trust technology in general, you can have all the documents saved and stored in one place. I don't think it replaces the actual documents, but I think in addition to, that's a good way to do that as well, because then again, you have one central depository for all your documents to be in one place. So keep that in mind. Taking shortcuts. Well, this is another one of those, okay? So that's a mistake that when you write a letter of wishes and you think it's going to be sufficient. It's essentially you say, this is what I'd like to see happen, but you don't have an actual officially witnessed and signed and executed will or trust. And again, it just opens up your estate for litigation. Now, the state has a lot of money. There's a lot more opportunity to litigate than, say, an average estate, but still, you'd be surprised what happens when there's some money involved. And it doesn't have to be a lot of money. Even little money, sometimes people do really funny things. And obviously, you know, Princess Di, she was young when she passed away. She probably didn't think she needed a will. And unfortunately, her tragic death kind of proved otherwise. She probably should have had something in place, and she didn't. So here are my points, right? So most jurisdictions will not consider a letter of intent as binding as a will or a trust. They will take this into consideration. Like I was saying, if you have a memorandum of personal property saying, I want this specific vehicle to go to this specific child, or I have this piece of jewelry I want to give to my daughter or to my daughter-in-law, or whatever the case may be, that's fine, but it's not a substitute to your will. So if it goes to court, if it goes to probate, the judge will take this into account, but it's not as binding. But you should have one, but not instead of, but in addition to having an actual will in place. And what I would also say, don't get overwhelmed, okay? These documents, as morbid, as informal, and lawyerly as they sound, but just really nothing more than your sort of last statement, if you will, on this earth. And so you can make that statement in any number of ways. It doesn't have to be complicated, but it's always better to have something other than to have nothing in place. So, and you can always change it. That's not something to be too worried about. That brings me to point number 9, as far as not updating wills on a regular basis. I will give you this example, right? This is obviously, you know, a well-known actor and well-known individual, and so he made that mistake, right? So, but I have clients in their 40s who I just happen to have a lot of clients who work in the private equity industry in New York City, and they're in their 40s. They're making a lot of money. They, you know, married. They've settled down. They now have kids, and I can't begin to tell you how many of them have wills that were drafted when they were single, not married, didn't have kids, and now these guys and women, they may have millions of dollars. They may have tens of millions of dollars in their name, and the wills have not been updated. Not necessarily because they kind of are forgetful and they work on Wall Street. You would think they know this stuff. Well, they do, they don't. They're just too busy doing what they're doing. They don't have time to think about it. And they don't think, hey, things changed. I don't really, I don't have to change an update or anything. But you do, yeah, kids? Do you want a judge to name a guardian for your minor child? Well, if not, update your will. So, practical solutions? Not so, right? So, like I was saying, not so easy to make a decision. Who's going to take care of your minor kids? Very difficult. Talk amongst yourself. I've seen couples in meetings looking at each other and giving each other this look like, I don't know. Oh, you want your brother to be? No, my sister should be the guardian. It happens all the time. But anyone you name would be better than one named by a court or by a judge or by a judge. Certainly, and I have nothing against judges. It just, again, they don't know your family. They don't know your circumstances. They don't know anything about your family. They will have to be bound and have to be adhering to the state law. And so if you don't want that to happen, make some sort of an agreement. If things change, make a decision, make the changes. You can always make changes in these documents, okay? So if you take anything away from this seminar, take away two things. Make sure you have the documents, and two, they can always change them. Don't worry about it. They're not perfect. They don't have to be perfect. You can always change them, okay? So let's move on. The last one, I chuckled when I saw that. It was saying that a Supreme Court justice would actually know this, right? Yet they didn't. Again, I have no idea how this happened. I don't know why this happened. But unfortunately, it did. Well, we all know what we say about lawyers who have themselves for a client, right? They are fooled for a client. Now, I'm taking a jab at Susie Orman here, not necessarily because I have anything against Susie Orman. A lot of people watch her. My wife actually likes her. She watches her show all the time. And I have a client who actually knows Susie Orman. So, but a lot of things that she says are entertainment. There may be right, there may be wrong. A lot of times I disagree with what she says. Remember, her show is an entertainment show. So a lot of things that she says are for entertainment purposes. And this goes for any other financial shows / news that you watch on CNBC. They're good. They're good presenters. They say things with conviction. They say things that come across as very authoritative truth, but it may or may not be in your particular circumstances. So when Susie Orman says, hey, just go to this website, download the package, it's going to be applicable in every state, or, you can just download a will for your own particular state, yada, yada, yada. Yeah, but it's going to be a boilerplate language that may or may not be applicable to your individual circumstances. So if you're about to hop on a plane and go on vacation with your entire family, you're concerned, sure, by all means, do this. And this is better than nothing. Having a will in place is better than nothing. Having a self-made will better than nothing. Downloaded will is better than nothing. But I wouldn't suggest having that in place, even if you think you don't have a complicated estate. There's many things that will come up. I think having a will drafted by a lawyer would be a better way to go. But like I said, I have nothing about Susie Orman. I think she does a good job. She's definitely a terrific entertainer. But some of the things she says you have to take with a grain of salt. But again, I'm in the business. I'm a little bit biased, so be that as it may. And I just need to wake up my laptop again. I don't know why it's doing this to me. Give me 1 second. Okay, I'm back in business. All right. Now, this is sort of a new thing. Think about your social media accounts, like all of us, most of us have them. I mean, I fairly recently joined Facebook, probably about 2 years ago. I, for the longest time, sort of refused. I don't think I'm a stranger to technology, and think email came out when I was at RIT, and that was a big thing, having an email account. So certainly not a stranger to it, but I didn't have a social account. I didn't feel the need to have one. I do now. I'm on Twitter. I'm on LinkedIn and all the other things. I have a blog. Think about all these social media accounts or your presence in social media as your digital afterlife. Some of the things you post, you probably want that to be either inherited by someone or for someone to be able to access that or download or preserve it or be part of your family governance or family values, family memories. The law is about 20 years behind. Right now, there is no law that actually governs digital assets. It will eventually catch up, but it hasn't yet. Now, Apple's been in the news not too long ago with the shooting in California when they refused to cooperate with the FBI to open up their iPhone, right? So, like I said, there is no law that is sort of specific to the digital assets. That's why a lot of attorneys are beginning to address this, or some attorneys are beginning to address this in the will by having a specific paragraph or a provision or a clause that just talks about this. And there's another side to it. When we sign up for Facebook or LinkedIn or whatever the case may be, or a Twitter account, you always have to click, they force you to click this little thing that says, I agree to abide by the terms of the agreement. Okay, very well, perfect. You haven't read it, you don't know what it says. Admittedly, I haven't either, but I guarantee you, it's not addressing succession. It doesn't say anything about individuals who may pass away and what happens to your account if you pass away. And there have been cases now where someone passes away and their loved ones are trying to get into their Facebook account and they can't. Facebook won't let them, won't reset the password. And you know what? It may be important. There may be a lot of things, a lot of memories are stored in there, and you would want to be able to go in and download, and you can't, and you'd rather save yourself some hassle. So in the absence of specific statute that governs this, just have something in the will that'll address this, and you can take this to court and present it to court, or at least have something to go on that's somewhat official, okay? Now, let's go back to Tony Soprano here. Again, you know, being from New Jersey, I couldn't resist. I loved that show. I watched it many times, and it was a quintessential Northern New Jersey guy, and it was a lot of fun to watch the show. His passing was really an unfortunate event. Having said that, the question I asked in the beginning of the presentation had to do with life insurance, right? So is life insurance subject to estate tax? One of the answers was made, it is not subject to income tax, but if the policy is owned by a trust, by a revocable life insurance trust, it is not subject to estate tax. The technical answer is correct, but think about it this way. Many times when a life insurance is presented, the individual will say, the individual selling life insurance will say the following: it's completely tax-free, it's entirely tax-free, there is no tax. Well, it's not exactly true. It is income tax-free in most cases. It may be taxable, income taxable in certain situations, but I'm not going to get into it. It's too technically sort of complex. I don't want to get into it. But in terms of the state tax, here's a simple truth. If you own the policy, if you take a policy in your own name, so I take a life insurance on my own name, I name my spouse as a beneficiary of my life insurance policy, and I die, the proceeds of the policy will be includable in my estate. So if I have a $10 million policy, in addition to everything else I own, which maybe just real estate, maybe a few other things, maybe 401k or an IRA account, but that $10 million just made an addition, taxable addition to my estate, just by the virtue of the fact that I own the policy, and I have owned the policy when I die. So dying, owning the policy is not a good thing necessarily. The solution is, like it's been suggested with one of the answers here, is to transfer the policy into a trust, a specific trust called irrevocable life insurance trust. Essentially what it is, it's a trust takes place of you as the owner of the insurance policy. Nothing else changes. There's some little things that need to be done around the edges, not complicated. The attorney drafts the agreement, the policy gets transferred into a trust. And then when you die, it's not in your estate, it's out of your estate. But also, consider the following. The policy gets paid out. And there's this, again, this misconception, you know, I don't have a taxable estate, the policy, I don't care, it's going to be in my estate, it doesn't really matter, I'm not going to have a taxable estate. Well, maybe you don't. Well, think about this. If you pass away, you have $1 million policy, and let's say you and your spouse die together. The policy gets paid to your minor kids. Well, let's say you're teenage kids. I mean, I have a teenager and a 9-year-old. Right? Do I want my 17-year-old to inherit $500,000 now, right before he starts college? No way. No way. Right? And he's a good kid, he's a great kid, but the level of maturity is just not there yet. So having a trust in place provides a level of protection for anything that may happen after your death. So if the proceeds of the policy gets paid into a trust, it'll stay in trust according to your wishes. And you can say anything you want. You can say all the income gets paid out to my kids, but the principal will stay in trust until they mature, till age 25, 30, or 35, whatever the case may be. Remember, and that's another thing that sort of gets missed, trust can be extremely flexible. You could make changes. You can make it as flexible as you wish. You can make it as restricted as you want. You can have that sort of hand from the grave control and control everything that happens in a trust, or you don't. It's completely up to you. But having a policy that gets paid outright is not always a good thing. Even if your kids are older, think about the following. Again, I have to be cynical, and I always, again, apologize to clients when I say I have to be cynical, SOB, in meetings, but that's what I get paid for. Let's say your child inherits your life insurance and they take the proceeds and they get married. Well, guess what? That's going to be part of the marital estate. So now their future ex-spouse will have a claim against your life insurance proceeds that got paid to your child. Do you really want that to happen? Hate to be cynical. Like Ronald Reagan said, trust they verify. Doesn't hurt to have a trust in place to protect against anything that may happen down the road, claims against your child. And I'm using the child as an example. It's just as applicable to a spouse, to anyone else you may be leaving life insurance proceeds to have them owned by a trust. And the takeaway here is don't be intimidated by the word trust. Oh, it's not that complicated. It's just an agreement, and it can be as flexible, as simple as you want, but it provides a level of protection. Okay, we have a question, and I'll get to it in a second. So, in conclusion, what I really wanted to say is this. Look, conditions are never right. It's never the right time. I don't want to think about it. I'll do it after I get back from vacation. I'll do it after the holidays. You know, my New Year's resolution is to do my estate planning docs. It will never happen. Make it happen. Do it. If you haven't looked at it, dig it out, take a look at it, get in with your attorney, make sure it's up to date. And like I said in the beginning, start with this. All we need is love. Think about your loved one. Think about what you want to happen when you pass. We all are going to pass at some point, right? So there's no way around it. So then the issue is, we're leaving behind our loved ones. Do we want them to be fighting? Do we want them to have all kinds of issues getting their hands on what we leave behind or not? And so make it as complicated or as simple as you wish, but start with love in mind. Okay, so I have a few questions here, and I think I'm at the end of my presentation at this point. I will just show you one more slide, and we'll get to the questions. I think I am close to or running out of time. We have about 4 more minutes. I certainly would like to entertain some questions. Here's what I wanted to say, sort of a quick and shameless plug for myself. I have set up my own new firm. I have been in corporate America for a long time, and but I decided, you know what, I think I will do it in my own way, and that's going to be the sort of new generation financial planning firms that's only based on fees, sort of like an accounting firm or a law firm. I'm not going to be selling any products, any life insurance or asset management. It's all going to be separate and apart from financial planning. And I have, because my firm is being set up and the website is being built. So I just provided my individual contact details. Feel free to email me, call me, look me up on LinkedIn. Happy to answer any questions. A lot of times folks don't want to share. It's a very private matter. Feel free, again, I have no agenda. There's no charge. You can just email me, and I'm happy to chat with anyone. Oftentimes I call myself an educator-in-chief. I'm certainly happy to talk to you about your circumstances before you go to the attorney. Just, give me a shout, give me a call, let me know. Okay, now with that in mind, we have a question here. Let me just read this and I'll respond to it. If you want to let,
Michael, let's read it aloud. If you own a life insurance policy when you die and you have a will that puts all property into a trust upon death, but the beneficiaries are your children, is the benefit money technically part of the estate or is it part of the trust?
Yeah, thank you, Cindy. I was just reading it through, trying to, so let me just give me like 2 seconds. Okay. Yes. If you own a life insurance policy, the proceeds will pass by beneficiary designation. And the beneficiary designation that you make in a life insurance contract or your 401k or your IRA is not subject to probate. In other words, beneficiary designation will trump your will. So it doesn't matter what the will says. The proceeds will pass according to your beneficiary designations. They need to be coordinated. And that's one of the things that gets missed all the time on insurance or 401k or an IRA account. Anything that passes by beneficiary designation will say one thing, but the will says another thing. These two things are not commingled. They're not necessarily aligned. You're going to have a problem. So that's the answer. Hopefully that answered the question. And fire away. Anything else that I've either missed or if you wanted to ask, I'm happy to. I think we have about a minute or 2 left, so I'm happy to entertain questions.
I'm sending you one over, Michael. I think it's more of a comment regarding a good estate planning lawyer.
Yeah, it's a good comment. So essentially the comment is the fee paid to a good estate planning lawyer is not for drafting the will. It is for the advice given to know what will provisions for estate planning techniques are most applicable to you. Sure. I mean, absolutely. I mean, I think that's the real value of any estate planning attorney or financial planner or an accountant is they will educate you. The question is, are they going to be on the clock when they're doing it or not? That's a different conversation. But yes, that's the fee. That's what you're paying for. And make sure, and a lot of attorneys have their own ways of doing things, and some of them are set in their ways. So it's not a bad thing to challenge them. Don't be afraid to challenge them, because what they've done in the last 20 years doesn't mean you have to do it the same way. You have the right to challenge. You have the right to ask questions.
All right. Well, thank you, Michael, and thanks to our audience. We are out of time. It's at the top of the hour.